Hello all. In this video, I will try to focus on the developments in the Delhi High Court over the last 2 days, triggered by a writ petition filed under Article 226 by Harsh Mandar. The main prayer in this petition was to issue a writ of mandamus to the Delhi police to file a first information report, the FIR, against some of the BJP leaders like Anurag Thakur, Kapil Mishra, among a few others, for some of the inflammatory statements they made over the last 1 month. To be precise, it was exactly a month ago, on January 27th, that Anurag Thakur repeatedly made, that tasteful and vicious statement like "देश की गद्दारों को goli maro salon," which was repeatedly being said by or followed up by the chants from the audience whom he was speaking to. Now, this was evidently aimed at those who were protesting against the government for introducing the Citizenship Amendment Act to 2019. And unlike some of the rumors that are spreading around, any reasonable person would know from the context that, of course, Mr. Junior Finance Minister was not referring to a Crosin goli or something of that sort. Anyway, specifically over the last 2 3 days, as all of you would know, things have really escalated in Delhi as in terms of how the violence has led to the death of several persons as well as extensive destruction of public and personal properties. These untoward and unfortunate events triggered a writ petition being filed by Mr. Rahul Roy. It's a different petition from Harsh Mandar's. So Rahul Roy requested the court to pass certain orders to ensure safety of victims who were injured and to enable treatment for them at the relevant nearest hospitals. Due to the unavailability of the Chief Justice of the Delhi High Court, Justice D.N. Patel, and the second most senior judge, Justice G.S. Sistani, the petition was placed for an urgent hearing before a bench led by Justice Murlidhar and which composed of Justice Anup Bhambani. And in I would say, a rarely unprecedented midnight hearing at around 12:30 a.m. at Justice Murlidhar's residence, the Delhi High Court ordered the police and other state authorities to ensure smooth passage of injured victims to nearby hospitals for immediate treatment. Now, this was something that happened on February 26th, Wednesday, early in the morning. In this like manner, due to the unavailability of the Chief Justice on that day because he was on leave, the writ petition filed by Harsh Mandar was listed before the division bench consisting of Justices, again, Murlidhar and Justice Talwant Singh. This happened after Harsh Mandar's lawyer, senior advocate Colin Gonzalez, mentioned the same matter early in the morning. That was yesterday, early in the morning, yesterday, February 26th. Yeah, that was a Wednesday. The bench heard the matter at around 12:30 p.m. in the afternoon yesterday. In this hearing, the Delhi High Court thoroughly emphasized, keeping in mind the urgency of the context and the importance of filing FIRs at the earliest time possible, directed the Delhi police authorities to file a report within 24 hours indicating whether an FIR would be filed on the basis of the accusations made in Harsh Mandar's petition about these alleged hate speeches by some of the BJP leaders that may have incited the violence in Delhi over the last 1 month and specifically over the last 2 days. Subsequently, this matter was listed to be heard again at 2:15 p.m. on February 27th, Thursday, that is today, to allow the police to file their report. Now, this report technically in procedural law is called as the ATR, which is the action taken report. So, interestingly, during the hearings, there was a very tight and heated arguments and conversations between the judge and the main lawyer who was representing the union government slash Delhi police. Solicitor General Tushar Mehta opposed the petition filed by Harshmardar. He argued that inflammatory speeches were being made from the other side as well. I mean, I hope you would understand what the other side refers to. And he targeted the petitioner for only picking up and choosing those three specific speeches by those BJP leaders belonging to the party. To which Justice Murlidhar responded by saying that, when the SG himself, the Solicitor General himself is saying that, these other videos are also inflammatory and sort of can be classified as a hate speech. Why aren't they registering FIRs even against them? That's the question that the public would ask. So there are beyond the statements or the speeches referred to in the petition. Seems like there are other inflammatory speeches being made, which the Solicitor General himself seems to be admitting. And very, very curiously, the Solicitor Generals argued further that they will register the FIR at an appropriate time. And the question by Justice Murlidhar was that what is that appropriate time? Because the premise of that question by Justice Murlidhar was that when this hearing was taking place on Wednesday, February 26th, the city of Delhi, in most of its parts, were burning with violence, right? Now, here is a situation where a crime or crimes have happened. Now, when a crime happens, the first thing that the procedural law system does is to file an FIR so that the crime gets documented, so that every authority, every stakeholder, not just the police, but also the magistrates, are there to keep a check on it. So I think as the Solicitor General seems to have missed the point that the FIR stage in a criminal case need not be a detailed assessment of establishing a crime, for which they need a longer period of time, and that is not necessary. Those higher thresholds of waiting and assessing a particular crime and then proceeding in a criminal case, those higher thresholds appear towards the later stages of a criminal case. Mainly when you talk about the stages of taking cognizance and framing of charges. The mere purpose of an FIR is to ensure that whenever a cognizable offense seems to have been committed, so that it gets documented in the criminal justice system, so that the judiciary, as I said, through the judicial magistrates, especially at the lower, the trial court level, can keep a check on the investigation into that matter, so that you, rather than merely leaving the police in the grey dark space without any accountability, especially in such cases where even the police seems to be complicit in the commission of certain crimes. Moreover, see, once an FIR is filed and if the allegations are later found to be, wrong or frivolous, they could be closed under provisions like Section 157 and Section 169, read with Section 173, which allows the police that level of discretion to close such investigations and such FIRs. But these are possibilities which come at a later stage in a criminal case. So therefore, enough safeguards are there. If the Solicitor General is believing that such frivolous cases, should not be entertained in this urgent manner. In fact, I'm glad that Justice Murlidhar was prompt at this particular time during the hearing to remember the Supreme Court's 5-judge bench decision in the very famous case of Lalita Kumari versus the government of Uttar Pradesh. This is a 2013 Constitution bench decision. which categorically interpreted Section 154 of the CRPC and said that whenever there is a prima facie case that is made about a cognizable offense, it warrants the registration of an FIR. Mind you, underline and bolden the words whenever a prima facie case is made out, right? So, it is not a detailed assessment of whether a crime can be established by a certain persons, but from the prima facie assessment of the facts, on the superficial assessment, it seems that there is a possible crime that has happened. Now we have to underline again that every day's delay in registering an FIR is crucial. The more and more you delay, the more and more the problems that are created. This is what I think Justice Murlidhar, when he highlighted the Lalita Kumari decision, emphasized the decision which emphasized that an FIR in a criminal cases, or in most cases, the first step of access to criminal justice that a victim or victims get, and more importantly, to hold to from a perspective of holding the police accountable, registering the FIR at the earlier stage helps in preventing manipulation of information, or ensuring that initial information about a crime is sort of registered in the beginning itself, so that there is no loss of information that could actually be useful for the later courts to adjudge the guilt or innocence of the accused persons. Justice Muralidhar also interestingly sort of observed that, to give you some information, if not for the hate speeches, the Delhi police has abhi tak filed around 40 odd FIRs, but those relating to destruction of properties, right? Of course, in the violence that ensued, properties have been destroyed. So 40 odd FIRs have been filed in those situations, and Justice Muralidhar's question was, if you recognize the existence of a crime in that area, why are you refusing to recognize a crime that has happened as far as hate speeches are concerned? So that's something that is very important. Finally, it is important to note that Justice Muralidhar led bench on February 26th, Wednesday, during that hearing, categorically sort of underlined in its decision that the police ought to examine all the inflammatory speeches that may have been made and with subsequent to which violence ensued in Delhi, and not merely to those statements made by the BJP leaders mentioned in Harshmandar's petition. So, as a matter of consequence, thereafter, the next day itself, on February 27th, Thursday, the matter was listed before the Delhi High Court's Chief Justice D.N. Patel's bench, which consisted of Justice Harishankar as well. Mind you, this is technically not a mala fide procedure whereby the case was taken out of Justice Muralidhar's bench, because Justice Muralidhar sat to hear these cases on Wednesday only because the Chief Justice was on leave that particular day. Otherwise, these writ petitions under 226 normally goes to the Chief Justice's bench, especially something on a public interest litigation initiative. Now, in yesterday's hearing, on Thursday, before the division bench headed by the Chief Justice, the Solicitor General seemed to have repeated the same argument that there needs to be some more time that needs to be given for the police to assess the case more properly and then file the FIR. Very importantly, what he said was, as per Justice Muralidhar's order, they have considered the issue of registering a hate speech FIR, and they submitted a short affidavit yesterday which stated that the police authorities have examined all the audio video materials which sort of depicts these hate speeches by the BJP leaders, and I'm quoting the Solicitor General, we have decided to defer the registration of FIR because the situation is not conducive on the ground to file an FIR, as they are currently focusing on maintaining the law and order situation in Delhi. So this is a new innovation in an FIR case, in a case where FIR is sort of being argued about. So one thing that we have to observe here is they have decided to defer the registration of an FIR. I think the natural premise that should have sort of been there before this is they have understood that there is a need for filing an FIR, right? So that means they have identified that there is a cognizable offense that has been committed, but the filing of FIR is only being deferred to certain stupid reasons of conducive environment. Now, after this, the Solicitor General sought further time to file a detailed response to Harshmandar's petition. This is a state argument that he made as on behalf of on behalf of the Union government. Now, even though the petitioner's lawyer, Advocate Colin Gonsalves, tried to raise the fact that this is hate speech, like for example Anurag Thakur's statement of Goli Maro Gadaro Ko, is a hate speech which on the face of it itself qualifies as a crime under various IPC sections, like your section 153A, which is promoting hatred and disharmony among certain communities on several grounds, or criminal intimidation under several provisions ranging from sections 503 to 506 of the Indian Penal Code. And Colin Gonsalves argues that thus, in such situations, Lalita Kumari's mandate ought to have been followed in this case. The court did not pay any heed to this. Rather, they granted 4 weeks for the Delhi police to file an action report in this case. The request to grant a shorter period considering the urgency was not at all given heed to by the Chief Justice. Interestingly, even though it gave only 4 weeks, I'm not sort of saying that it is only 4 weeks, but the ridiculously interesting fact is the matter will be next heard only on April 13th, 2020. The matter has still then been adjourned. This is the considerable, exorbitant delay that has been caused by the court. Now look at the contrasting picture that you see in the Delhi High Court proceedings in the matter of a few hours of gap. On Wednesday, when Justice Muralidhar was sort of hearing the matter, here is a emphasis on urgency that was being imposed. 24 hours was the only time that was given to the police to file an action report. Here, they are giving 4 weeks, plus the matter is being adjourned to April 13th, which is from today onwards, I think around 40 to 45 days away. Now, this is all despite section 154 of the CRPC and Lalita Kumari case mandating the police to record FIRs in every information relating to commission of a cognizable offense. Mind you, the court led by the Chief Justice did not ask a single question to the Solicitor General when the Solicitor General said that we have considered the issue of registering FIRs in the hate speech cases, and then they submitted a short affidavit. They never asked a single question as to why did they decide to defer the registration. There was no single question posed to the Solicitor General about did they actually confirm there was a cognizable offence or not. If not, on what basis did they decide that there was no cognizable offence disclosed. None of these questions that a basic criminal procedure judge should have asked was not asked. This attitude of the court, recently in the recent cases before constitutional courts, to sort of take every state argument as the gospel truth, that need not be questioned, has been a constant observation. And on a procedural angle, now essentially speaking, filing of FIRs which should have been done swiftly, have become now subject to certain conducive nature of the current situation on the ground, unfortunately. So, the delay that the Delhi High Court has been caused in this matter because of the last day's hearing. And I would like to quote what famous criminal lawyer Majid Memon said recently, that delay in lodging an FIR is a grace in law to the actual offenders of crime. Anyway, So before I part with this video, it is important for me to highlight a similar case on the same set of facts that was going on before the additional chief metropolitan magistrate Vishal Pahuja's court at the Ross Avenue courts in Delhi. These proceedings before the chief metropolitan magistrate came about because of a private criminal complaint filed by Brinda Karat, the famous CPM leader, who filed a criminal complaint under section 156 clause 3 of the CRPC, in which she alleged that when she argued that the police refused to record her information about the inflammatory hate speech made by Anurag Thakur in January, end of January, saying that that information was not recorded as an FIR by the police. Therefore, she requested the magistrate under 156 clause 3, which the magistrate is authorized to do, to order the police to file an FIR in the same case. Now, this complaint by Ms. Karat was entertained by the Metropolitan Magistrate on February 5th, early this month, during that hearing, which the magistrate directed the police to file a action report, the ATR, the action taken report, stating whether they would decide whether or not to file an FIR against Mr. Anurag Thakur. So overall, the police was on February 5th given around 20 days to submit this report. Now, in response, while Justice Muralidhar was hearing Harsh Mandar's petition on February 26th, Wednesday, in response to Brinda Karat's application before the Chief Metropolitan Magistrate, the Sub Inspector of the Parliament Street Police Station submitted the action report in which they stated that prima facie no cognizable offence has been found to have been committed by the accused, which is Mr. Anurag Thakur, and any of those incidents of violence that took place in Delhi thereafter, including over the last 2 days, are independent actions which do not have any connection to the speeches mentioned in the complaint. So, in this particular matter, the Chief Metropolitan Magistrate has reserved its order, which will be rendered on March 2nd, by when we will get to know whether the magistrate will direct the filing of FIR or not. So, I would say there is still some hope in this particular matter, despite the Delhi High Court, taking a completely unjustified and unreasonable measure in the writ petition by Harsh Mandar. I just hope that the police uses this level of legal scrutiny before they filed all these numerous FIRs under section 66A of the Information Technology Act, which has been long held to be unconstitutional and has been struck down by the Supreme Court in 2015 in the Shreya Singhal judgment. Anyway, as a last point, even if a cognizable offense, needs to be disclosed for an FIR to be filed. My point is, even if a cognizable offense like a section 153A, promoting enmity between different groups on grounds of religion or any other such grounds, using spoken words or any other actions, even if that cannot be proved with respect to Anurag Thakur's statements, which is like goli, maron, salon, such statement definitely falls, if not under 153, it definitely falls very directly as a crime of criminal intimidation under sections 504 to 506, which are non-cognizable cases, non-cognizable offences. As a matter of procedure, in such cases, the magistrate need not bother about the police. In fact, they can take someone like Brinda Karat's private complaint and take cognizance under it, under the section called section 190A of the CRPC, and proceed with that case as a private criminal complaint case as opposed to a FIR case. And that's something that is mandated and or possible under the CRPC. For a criminal case can go through two directions. It can either go through the police and become an FIR case, or it can go through a private criminal complaint procedure. So I hope this argument is raised as an alternative by the lawyers before any of these appropriate courts, so that this particularly seeming to to be crime is not sort of taken out of the folds of the criminal justice system. So that's all from my side. Thank you for listening.